The U.S. Constitution does not explicitly provide for a right to privacy. Some state constitutions do, such as California's. However, constitutionally protected privacy rights have been fashioned out of the Fourth Amendment's protection against unreasonable search or seizure. In the leading Supreme Court case on privacy rights of public employees, a public employer had placed an employee suspected of wrongdoing on administrative leave and then conducted multiple searches of his office. The court decided that public employees enjoy no constitutional protection from workplace searches, and that public employers need not establish probable cause before conducting workplace searches. Plaintiffs must first show that they had reasonable expectations of privacy under the circumstances. If this is shown, public employers must defend the reasonableness of their actions both at their inception and in their scope. Searches are reasonable at their inception when there are reasonable grounds for believing that they will produce evidence of wrongdoing or when they are necessary for non-investigatory work-related purposes like retrieving files. Searches are reasonable in scope when the measures employed are not excessive in light of the purpose of the search and the seriousness of the suspected misconduct. Public employers need not establish probable cause or obtain warrants before conducting workplace searches. However, they must be prepared to defend the reasonableness of the search and other actions that infringe on employees' reasonable expectations of privacy. The idea of reasonable expectation of privacy is a key concept in workplace privacy law. If an employee cannot be said to have a reasonable expectation of privacy under the circumstances, he or she will not prevail in a privacy claim. One factor often considered by the courts is the existence of a policy or prior notification to employees regarding the limits of their privacy right. To a great extent, if employers tell employees that they're subject to monitoring, searches, and other arguably invasive actions, those employees will not be deemed to have any reasonable expectation of privacy. Employers should establish privacy policies that alert employees to the limits of their privacy rights in the workplace. Other circumstances under which a reasonable expectation of privacy is more likely to be found include intrusions that take place in areas of the workplace that are usually regarded as private or occur outside the workplace. Intrusions that are effected through deceptive, secretive means like hidden cameras may also violate the right to privacy.